I'm going to go first to our first speaker, who is Gunda Schumann. And Gunda is a lesbian activist. She's Lat's Reloaded EV, member of the board. She's a lawyer, sociologist, author, and has been involved in WDI pretty much since it started. The title of Gunda's talk is German Self-Identification Act is Violating International Human Rights Law. So thank you so much for coming, Gunda, and over to you.
First, I will give you an overview over this not so easy topic. Reem Al-Salem addressed an official letter to the German Foreign Minister on 13th of June 2024 regarding the German Self-Identification Act, I call it SBGG, and using testimonies from female witnesses of male violence. In this letter, she criticizes violations of human rights of women and girls that SBGG already entails from the perspective of international law. She does not fail to mention that the proposed law has met with resistance from a large number of women's organizations and activists due to the risks it poses, especially for female victims of male violence. She draws Ms. Baerbock's, the foreign minister, attention to Germany's obligations to comply with codified human rights and asks her to answer her questions in detail. Ms. Baerbock didn't answer herself, but boasts with feminist foreign policy and her fight for abortion rights and against femicides. But first, the arguments of Reem Al-Salem. First topic, risks of concrete violence against women, including further sex-based violence against them. According to Reem Al-Salem, the SBGG in no way takes into account the specific needs of women who are threatened with male violence or who have already experienced male violence, because the law does not provide for any measures to prevent the abuse of gender registration procedure by sex offenders and other perpetrators of violence. In the following, Reem Al-Salem names two female witnesses, one of whom experienced sexual violence by a so-called non-binary man, and the other reports how young lesbians are forced into sexual relationships with men who identify as quote-unquote women. As to Reem Al-Salem's opinion, they prove how legal gender recognition could be instrumentalized on the basis of self-identification of sexual offenders, and it would facilitate access to their victims for those who have already committed violence against women and children in the past. In Reem Al-Salem's opinion, these acts of violence by mostly male sex offenders will increase with the entry into force of SBGG because, in addition to self-declaration, these people will also have the opportunity to have their identity documents changed accordingly. At the bottom of each slide, you see the sources of international law. Number 2, undermining single-sex spaces for females and associated trauma. Reem Al-Salem sees a risk of abuse in fine reinforcement, which protects the new identity of trans-identified men, in particular because it endangers single-sex spaces that serve to protect women and girls. In particular, she mentions women's prisons, access to which for men has not been regulated by the SBGG. Please note, these are my comments now. Prison laws that regulate accommodation of male and female prisoners are the primary responsibility of the German federal states. To date, the states of Berlin, Hesse, and Schleswig-Holstein have prison laws that allow allow trans-identified men access to women's prisons. All of these state governments have a coalition with the Green Party, by the way. Rona Duwe also criticizes the fact that SBGG emphasizes contractual autonomy, domiciliary rights, and statutory autonomy, but provides no further regulations for cases of conflict. Private operators who want to maintain single-sex spaces could face fines or criminal investigations if they want to know the former sex of the person seeking entry, or simply because they publicly express their opinion on the subject of single-sex spaces. Please note, the problem for private operators is that the legislator shifts the resolution of such conflicts to the judiciary. The German General Equal Treatment Act, abbreviated AGG, serves as a legal basis for admission or its denial. The problem here is a lack of clarity regarding the legal definition. Question: does the prohibition of disclosure also apply in the case of an obvious appearance? That means if the person requesting entry is clearly recognizable as a man. Even if prohibition of disclosure is applicable in this case, the allegedly injured party would still have to prove in court that the attacking party had the intent to harm. 3 other witnesses who are victims of sexual violence have reported to Rona Duwe that their mental health suffers from the presence of men in their shelters, regardless of their identification, and that they would consequently exclude themselves from social life if they could not be sure that the rooms are reserved exclusively for women. Rona Duwe emphasizes the dangers of re-traumatization when victims of sexual violence are forced to share their spaces with men. On top of this, there's a ban on disclosure, which is particularly negative for women, in her opinion, when it comes to spaces for their private part. Rona Duwe points out that in the area of human rights conventions, different treatment on the basis of sex and gender identity is certainly permitted if it is based on reasonable and objective criteria, pursues a legitimate aim, and if its consequences are appropriate and proportionate to the legitimate aim being pursued. In this specific case, this would mean that in justified cases, there may be single-sex spaces for women to which trans-identified men do not have access. That is applicable for safe spaces, but also for autonomous spaces for lesbian women, for example. Number 3, lack of trauma-informed approach for women and girls who are victims, survivors of violence. In RA's view, all states parties have an obligation under international law to have legal procedures in place to prevent stigmatization and re-victimization, especially in cases of sexual and gender-based violence. Equally important are procedures that prevent the use of stereotypes that blame the victims or prevent them from going public with their experiences for fear of re-victimization. RA names 2 female witnesses who reported having been victims of sexual and gender-based violence by men who described themselves as non-binary or transgender. The women insisted that they had special protection needs as female victims. Both were criticized for going public with their experiences. Their testimonies were each dismissed and they themselves were labeled transphobic. Furthermore, RA notes that there is no information on whether the state authorities have investigated these cases nor whether there are procedures in place to prevent the re-victimization of women who have experienced sexual violence through access of trans-identified men to single-sex shelters and services. Number 4, obligation to collect, disaggregate data based on sex. Rona Duwe insists that states should collect up-to-date and reliable data on gender-based and sexual violence, indicating the sex of victims and perpetrators and the detailed background of the violent offenses. These data are particularly important in order to correctly classify sex and gender-based crimes against women, offenses that are mostly committed by men as perpetrators against women as victims. SBGG, on the other hand, says nothing about how the state intends to deal with the lack of reliable data on an individual's sex and the impact that the lack of such data has on the categorization of these offenses against women and girls. Number 5, the negative impact on women's and girls' higher standards of mental and physical health. Rona Duwe names a detransitioner who reports that she was not sufficiently informed about the procedure. She underwent hormone therapy and a double mastectomy without understanding the short and long-term implications and consequences for her health and physical well-being. RA states that under SBGG, therapeutic counseling is no longer required for gender transition. It remains unclear, however, how the legislator intends to ensure that people receive counseling in order to adequately understand the consequences of gender reassignment. In view of the fact that the SBGG also authorizes gender transition of minors, it is also particularly important to ensure that these children and their families understand the consequences of such an intervention for their mental and physical health. According to the findings of the UN Committee on the Rights of the Child in its General Comment number 15 of 2013, children's ability to give consent must take into account their maturity and age. Furthermore, children's welfare is paramount. SBGG, which allows adolescents from the age of 14 to legally change gender, even against the will of their parents, provided it has been authorized by a family court, calls into question the child's welfare, especially with regard to the responsibility and rights of the parents who have to ensure the best interests of the child. Furthermore, the connection between social and medical transition is irrefutable, even if the legislator explicitly states that the SBGG only regulates social transition. Number 6, information on the lack of safeguards for the best interests of the child, particularly concerning girls. Rona Duwe is concerned that under SBGG, children under the age of 14 are not protected from being victims of forced legal transitions by parents or other guardians, particularly because of the power imbalance between children and adults. Research has generally shown that lesbian, autistic, and depressed girls are particularly susceptible to social influence and pressure, which leads them to assume that the solution to their problems lies in transitioning to the opposite sex. RA notes that SBGG does not contain any protective clauses to avoid such risks and thus exposes girls to particular health risks in the case of medical transition that often follows. Number 7, information on the risks to freedom of expression, religious freedom, and the prevention of violence due to the ban on disclosure. Rona Duwe believes that the ban on disclosure, which is subject to a fine and makes it an offense to disclose a person's biological sex without a public interest or a credible legal interest, has a serious impact on women and girls. My note: as mentioned earlier, it is essential that the biological sex of a transition person must not be generally known or known to the addressee, and the disclosure of the biological sex must be made with the intent to cause harm in order to fulfill an administrative offense. The problem here is the ambiguity in the legal definition. Does the prohibition of disclosure also apply in the case of an obvious appearance, male facial features, beard, and etc., or not? In any case, the prohibition to name one's biological sex is a severe violation of the freedom of expression. Okay, that was Rona Duwe. Now the reply. The federal government rejects Rona Duwe's allegation that it violates a number of human rights obligations by recognizing the right to self-determination. Rather, it states that the SPGG is based on solid human rights standards. The foreign minister has not replied herself. The reply comes from the permanent mission of the Republic of Germany to the United Nations. My note is to this first argument of the government. Rona Duwe does not say that recognizing the right to self-determination is in itself a violation of human rights. She says that its uncontrolled consequences are likely to violate the human rights of women and girls. The German government goes on citing legal sources. First, the Basic Law, which is the German Constitution. The government says, the main motivation for the enactment of the SPGG was precisely to protect gender identity, which is in line with the general right of personality enshrined in Article 1 and 2 of the Basic Law. My note, however, the fundamental rights under Articles 1 and 2 of the Basic Law, which also include gender identity, that's right, must be balanced by the legislator with other possibly competing fundamental rights of women enshrined in Article 3.2 and 3.3 of the Basic Law. The federal government does not mention this tension ratio. Number 2, international legal sources and policy. Furthermore, the concept of SPGG would be in line with international recommendations and regulations, says the German government. A. In 2010, the Council of Europe issued a recommendation on combating discrimination based on sexual orientation or gender identity, in which it called on member states to take appropriate measures to ensure legal gender recognition, including by enabling the change of name and gender in official documents in a quick, transparent, and accessible manner. B. This recommendation would be in line with various judgments of the European Court of Human Rights, ECHR, in particular with regard to the right to respect for private and family life, Article 8, EHRC. My note, the quoted judgments of the ECHR refer exclusively to the right of transsexuals to change their gender entry. The effects on women's rights have not been the subject of the respective proceedings. C. Germany also refers to an initiative by 28 member states of the United Nations led by Argentina and supported by 66 organizations which are campaigning for the legal recognition of gender identity through self-identification. My note. The number of 28 UN member states is relatively small in view of the total of 193 member states. In addition, as to my information from Maria J. Binetti, WDI, Argentina is not involved in that initiative anymore. D. Finally, Germany cites the report of the High Commissioner for Human Rights from 2019 and that of the independent expert on sexual orientation and gender identity, abbreviated SOGI, from 2018, which have advocated for the same goal. My note, the SOGI expert has been fighting for years, not for the recognition of lesbians and gays, but exclusively for trans-identified persons. Next argument, legislative procedure and meaning and purpose of the SPGG. First, the SPGG was allegedly subjected to a thorough review during the legislative process through the involvement of NGOs. My note. The NGOs included by the lead ministries of the federal government were handpicked following the transgender ideology. Although other NGOs were also able to publish their statements on the websites of the Federal Ministry for Family Affairs, Senior Citizens, Women and Youth, and the Federal Ministry of Justice, including Let's Reloaded, they were not taken into account in the formation of political opinion. As a consequence, the effects of the SPGG on women and girls were not at issue. Second, the following institutions also supported the SPGG according to the German government: German Women's Council, German Institute for Human Rights, Amnesty International, Federal Association of Women's Support Services and Women's Crisis Helplines, and the German Association of Women Lawyers. The German Women's Council, an umbrella organization with 60 women's associations, supposedly explicitly welcomed the SPGG, particularly denouncing the increasing violence against intersex and trans people who identify as female and warned against the reproduction of mistrust and false stereotypes by associating the law with transgender persons posing a threat or being violent. My note. Voices critical of gender in Germany, especially those of the autonomous women's and lesbian movement, the political opposition, and the medical profession, are completely ignored. 3. Purpose of SPGG. The SPGG only allows non-binary, intersex, and transgender people to adapt their civil registry entries and identity papers to their gender identity, the government says. My note is, the SPGG goes far beyond this. It allows any adult person to have her or his gender entry in the civil register changed once a year by self-declaration without any state control. Furthermore, this time limit does not apply to minors. The government goes on. It does not make any other legal changes, for example, to the General Equal Treatment Law. The SPGG is therefore not concerned with access to single-sex spaces. My note. SPGG helps the trans activists to conquer women's spaces insofar as sex is equated with gender identity. The AGG does allow exceptions to prohibited discrimination for the protection of privacy, for example, of women. But in the event of a legal dispute, in the absence of a legal clarification, courts ultimately have to decide whether or not trans-identified men may be excluded from women's spaces for the reasons mentioned in the Equal Treatment Law regarding of their registered gender. Gender-specific spaces combating violence against women and non-binary, intersex, and transgender people. First, the safety of single-sex spaces, especially women's shelters, would have always been a concern of the federal government. Violence by so-called cis men, transgender speech, against women is a fact. My note. The violence of trans-identified men towards women, see the statements by Rona Duwe, is simply ignored. The Association Frauenhauskoordinierung, in English, Women's Shelter Coordination Association, also welcomed the SBGG and expressed its concern about the increasing violence against intersex and transgender people who identify as female and about their particular marginalization. My note. Autonomously organized women's shelters are usually non-profit associations and therefore dependent on state support. They are therefore ultimately faced with the choice of becoming trans-inclusive or having to do without state support. Women's shelters have been founded since the 1970s by women of the autonomous women's movement to protect women from male violence. Today, men can often demand entry due to trans inclusivity if they have experienced violence. However, this does not necessarily mean that biological women and men with a different gender identity are treated equally by the staff at the Women's Refuge. The gender-specific role behavior also continues in women's shelters to the detriment of women. However, this problem is not discussed publicly, rather in the social media. Number 2. Germany shares Rona Duwe's goal of eliminating gender-based violence. That is why A. Germany ratified the Istanbul Convention in 2017. My note. In the Istanbul Convention, unfortunately, woman is not clearly distinguished from gender identity. See Article 3.f and Article 4.3. B. The government would currently also work on the federal government strategy to prevent and combat violence against women and domestic violence. My note. There is an EU Commission proposal on this, which, because it conflates sex and gender identity, met with protests in 2023 from radical feminists, including Let's Reloaded. C. And on a bill to support survivors of gender-based violence. My note. The bill is called Violence Assistance Act. It is conflating sex and gender identity and does not provide single-sex spaces for women in women's shelters. Because of its voluminous area of application, female and male victims, it would require a huge amount of taxpayers' money and will therefore have little chance to become law. D. The cause of violence against so-called cis women, transgender, non-binary, and intersex people would have common roots based on misogyny and gender role stereotypes. Therefore, strengthening the rights of transgender, non-binary, and intersex people, which would eliminate harmful gender role stereotypes, would also benefit women and girls. My note. This assumption completely fails to recognize the sex-based interests and needs of women and can only be described as ideologically driven. Rona Duwe's arguments regarding violence by trans-identified men towards women are not addressed. E. Violence against transgender, intersex, and non-binary people would have increased. The government says in 2022, there would have been 417 politically motivated crimes against these people in Germany. My note, it would be interesting to list and compare the increase in violence against women, for example, femicides, What about the increase in violence by trans-identified men against young lesbians, for example? Unfortunately, there are no figures on this. We will take care of it. Child welfare. The best interests of the child would be protected by SPGG, according to the government. A. The suicide rates of gender dysphoric children would be alarming. My note, this is scientifically controversial. See the German Medical Journal 2022, with the title When Puberty Gets Stopped. There you have scientific discussion on this. B, the German Ethics Council and the Child Protection Association would advocate support for children's gender identity. My note, the Association of Parents called Trans-Teens Sorgeberechtigt, Trans-Teens Care Authorized, which has been educating the public about the danger of transgender ideology for years, is not mentioned. Of course not. C, the federal government also points out that children aged 5 and over would have to be present at the registry office if their gender entry is going to be changed by their legal guardians. In addition, the declaration of the young person before the registry office or the custodian would also have to contain information about previous counseling. Incidentally, the SPGG would only regulate change of the legal gender entry, which could be changed again at any time. My note, these arguments in no way take into account the differentiated argumentation of Rona Duwe. For example, the connection between social and medical transition, the ability of children to give consent, the lack of safeguards for children under 14, the best interests of the child, and the child's right to identity. My conclusion, for the federal government, there are no differences in interests between women, girls, and trans-identified men. Single-sex spaces for women, including lesbians and girls, are therefore irrelevant. According to the federal government, strengthening the rights of trans-identified persons also benefit women and girls, as a cause of discrimination against both groups of people is rooted in patriarchy. Following this logic, violence by trans-identified men against women, including lesbians and girls, does not exist. On the contrary, the former are increasingly victims of violence. Their potential perpetration as men vis-à-vis women as victims is not being addressed. The rights of girls to informed consent, especially at the critical developmental stage of puberty, and the connection between social and medical transition are completely ignored. Here, ideology stands against facts. Thank you for your attention.